大家好，我是秦苏珊律师。那今天的话呢，我跟我们的律师团队，我们讨论一下 BIA 上诉，也就是移民委员会上诉。那通常的话呢，你面谈没过，案子就转到了移民法庭。移民法庭打庭，如果大庭没过的话呢，你就有递减令。那通常法官会给你30天的时间去上诉到 BIA。那30天上诉了以后，那大家都担心，那我这个上诉到 BIA 我的通过率是什么等等，所以大家都特别担心。那今天的话呢，我就想跟我们的洪法官去分享一下，我们有2个就是特别快的，然后这2个 BIA 上诉我们都赢了。Hey Judge Hum, so I just wanted to discuss with you the 2 cases that we got the case remanded from BIA back to the lower court. One was 8 months from the time we appealed to BIA, and then the second one was like a year. You know, usually BIA cases, the wait time, it's 3 years, 5 years, even longer.
Really?
But these 2 cases were pretty, fast. So I just wanted you to maybe share with everybody, what's the secret for getting the BIA remanded back?
Well, it's not really a secret. It's what the law requires. Now, let me explain. The BIA is the Board of Immigration Appeals. It is the next appellate level beyond the immigration judges. If there's a request to appeal the case or that you disagree with the decision of the immigration judge, it is taken to the Board of Immigration Appeals, which is the BIA. As you mentioned, we were successful in 2 cases that were remanded back from the BIA because they found error in the judge's determination. One, I believe, was error with regard to the evidence and the assessment of that evidence. And the second was incorrect application of the law. But the board has a very limited authority. The Board of Immigration Appeals has a very limited authority in terms of reviewing cases from the immigration court. And what they view as the standard is clear error. And that's a high burden, but nonetheless, it is a bar that needs to be addressed in the appellate process. Now, appeals for individuals who are not detained is advantageous because the process, as you indicated, in one case it was 8 months, the other was a year, and generally you've indicated it takes maybe 3 or 4 or even 5 years before a board makes the determination, and that's because of the backlog of cases that it's handling. The immigration court went in 2018 went from, I believe, 218 judges to a point where it was over 500 judges. Now it's been reduced a little because of the current administration termination of some judges on their probationary period. But nonetheless, because of that increase in immigration judges, there were more cases that were determined, and I suspect there were more appeals that were taken to the Board of Immigration Appeals. So for those who are non-detained and feel that their decision was incorrect, I think it's advantageous to take an appeal. It provides additional time here in the United States, the ability to work, and possibly success on the appeal to lead to a permanent resident status. As to those who are detained, that's a very tough decision because in most cases, you'll have to remain detained until there's a determination. However, the board does expedite those appeal cases from the immigration judges in detained settings, and it usually takes 5 to 7 months. But that's still 5 to 7 months that the person is detained in the detention facility. So in some instances, it may not make sense to appeal. In other instances where the person has other considerations and other factors and they feel that the decision is incorrect, it would be advantageous to appeal. But let me state this. Our firm, with offices in California and New York, have been very successful in the appeal, either getting them remanded back because there was error on the part of the court, or reversing those determinations and leading to asylee status and then eventually permanent resident status. But that is the appeal process with the board. And I recommend that if you do have questions concerning that, you consult with a competent immigration attorney.
刚才呢就是洪法官就给我们讲了，就是说我们这两个 BIA 上诉成功驳回到低级法院的这两个案子的话呢，那他在就是上诉的这个辩护词里面，就是一个就是说找到了那法官在打大庭的时候呢，就是说筛选这个证据出了漏洞。那第二个的话呢，就是说法官采用了就是不准确的这个法案以及法律去裁定这个案子。那么我们的这个洪法官呢，就是揪住了这两点，所以我们成功的把这个 BIA 的 case 就是赢了书面诉讼赢了，然后这两个案子呢驳回到了低级法庭。那这案子驳回到低级法庭意味着什么呢？也就是说我们英文叫 remanded back to the lower court， 那意思就是说这个 case 驳回到低级法院，回到了当初审大庭的这个法官这里。那法官的话呢，他要么直接就宣判就给你一个新的命令，或者就是说他重新再审一个庭，然后呢再就是重新纠正几个地方，那基本上这样子的话案子就能通过了。那很多时候有些人他不明白，就说那是不是我直接驳回到低级法庭，我是不是直接就能拿到这个通过大庭的命令？那不一定的。所以就说如果说你很幸运你的案子驳回到低级法庭的话呢，也一定要找律师做一个详细的咨询。那接下来我就是跟我们的 office 的总经理聊一下就是费用的问题那个王经理，就是最近的话就是 BIA 费用一直在Bia，你能讲一下最近我们遇到的哪些挑战吗？就是关于费用这方面 BIA 的费用。
好的。达尔美法案通过之后呢，那么移民局还有移民法庭呢，都对这个费用，当然也包括BIA 上诉委员会，这个费用呢都进行了调整。它这个调整幅度非常大，将近10倍，从过去的110美元变更到了1010美元。对，而且他这一块内容应该是 case manager 来回答但是我是经理，那么也起到一个监督作用。他这个就要像提交这个上诉，那么也是必须要强制性电子化提交的这也非常明确。那么咱们同样也是在线去支付这个费用。对，这里我想到一个问题如果大庭输掉了，咱们是只有一个途径，就是说上诉去就说赢得这个案件发回重审，那么有没有可能做就说重开案 reopen？
对，就是那我们这边的话就是说大庭失败的情况下有的时候有的人他并没有做 BIA 上诉，那他直接就提交一个叫 motion to reopen， 也是有这么一回事。那我接下来会跟我们的洪法官去讨论一下。Hey Judge Ham, Tyler made a very good question. He said once the individual hearing or the merits hearing has been concluded, so a person has a choice to file BIA appeal, or in the alternative is, can the person file a motion to reopen with the judge who, denied the application?
Yes, under the Immigration Nationality Act, there is a process in which you can ask the judge to reopen the case because of new evidence that wasn't presented and that may be pivotal with regard to the outcome of the case, or reconsider based upon an error of law. In both of those situations, in making that request to the court, it does not extend your time to appeal. Your 30 days to file a notice of appeal continues to run. So it may be problematic sometimes to make a motion to reopen or reconsider because you will invariably lose the right to appeal that decision by the immigration judge, but you do have the right to appeal the motion to reopen or reconsideration if the judge continues to make error with regard to that facet of your motion. But understand, making those two motions does not extend your time to appeal, but you can appeal the denial of a motion to reopen or denial to reconsider. But that is an option that an individual has if they feel that the judge's decision is either an error in fact or an error in law, or fail to consider, you wish the judge to consider new evidence that has recently come to your attention that was not available at the time of the hearing, which may change the outcome of your case. So that a motion to reopen can be made in that circumstance.
So the motion to reopen, is it with the lower court or with the BIA?
No, it's with the lower court. You're making the request back to the judge to reopen the case, to either consider the case based upon new evidence that has come to your attention that was not available at the time of the hearing, or you feel that the judge has made an error in fact in the assessment of his decision and denial. So in both of those situations, it goes back to the court or to the judge that made that determination, and he has the option to grant or deny that. If he grants it, the case does not have to be appealed, but you do get an opportunity to present either additional evidence to the court, additional testimony if necessary, and or in the circumstance where there's an error in fact, you get to present the correct fact and argue the correct determination based upon that set of facts. But it goes back to the immigration judge or court.
Mm-hmm. And so recently we had a case. So this particular person went in front of the judge in Santa Ana court. But he said at the end of, the judge denied his application, but at the end of the hearing, the judge said he can file a motion to reopen with him instead of BIA, because if he files a BIA appeal, then the lower court loses jurisdiction over the, motion to reopen. And the judge said he can file a motion to reopen based on ineffective assistance of a counsel. So is that also something that he can file with the lower court based on ineffective assistance of counsel, like Lozada?
Lozada, yeah. That's an equitable remedy that the immigration courts have recognized, and that's a determination that was made by the U.S. Circuit Courts. Where there's been an error on the part of an attorney, not strategic error, but an error that would affect the outcome of a person's case, he's provided ineffective assistance of counsel. That does two things. One, it tolls the time to either appeal or to make a motion or to do something, because you may not have discovered this within the time period, the 30-day time period or 90-day time period for a motion to reopen or reconsider. But you can ask the court based upon the ineffective assistance of counsel, and you have to show that there was some prejudice, some harm to your case as a result of the attorney doing or not doing something. Once you show that, and once you demonstrate to the court that you've given the attorney every opportunity to explain himself, the court can reopen your case and listen to either the new evidence or the additional evidence or whatever arguments that you want to make that the attorney didn't make below. Now, ineffective assistance counsel comes into play a lot of times, but it can come in other circumstances, but a lot of times where the individual says, I did not receive notice of the hearing, and the court issues an in absentia order. You're supposed to appeal that within 30 days. But if you didn't know about the in absentia order because of the error by your counsel, then that's ineffective assistance of counsel. And that could be a grounds to reopen the case, to put you back on the proper setting toward your relief hearing.
Okay. Lately, since a lot of asylum cases have been barred by CLP, the Biden May 11, 2023, the executive order. So let's say at the merits hearing, the attorney didn't file a CLP brief, and then the judge denied the application purely because the applicant didn't file CLP brief. would that constitute as, let's say if this person files a motion to reopen, can they use that grounds because the attorney didn't file the CLP brief as grounds of ineffective assistance of counsel?
Yes. If that was the reason for the termination or for the order of removal on behalf of by the immigration judge against the respondent, that his case application for his relief is terminated because he failed to comply with the court's requirements to submit a CLP brief. That could be grounds for ineffective assistance to counsel if the attorney had knowledge that he was supposed to provide this brief to the court before the merits proceedings. So, yes, it can be. It can be a equitable remedy that you can seek before the court to reopen the case because of the attorney's failure to do something that he was required to do as ordered by the court with either a pre-hearing order or pre-hearing instruction at the time of a master calendar proceeding. So where the attorney had failed to act when instructed by the court, that could be the basis of ineffective assistance to counsel.
对，刚才呢就是洪法官大概的讲了一下，就是刚才王经理问的一个问题，也就是说那除了比方说你大庭失败了，除了 BIA 上诉，那是否可以向就是给你递解令的那个低级法院的法官去做一个重新开案？那洪法官说确实是，那基于好几个原因，一就是说你的律师失职，比方说你的律师在代表你的整个案子过程中，如果他没有提交文件，那导致你的拿了一个递解令，或者是说该交比方说是511的那个 brief 他没交，那这种情况也是可以的。那还有就是说在你打大庭的时候，那比方说有一个特别重要的证据，你在打大庭的时候呢，你没有办法拿到这个证据，但是这个证据有可能就会决定你这个案子能通过还是不能通过。那如果说打完大庭之后你突然有了这个新的证据了，那么我们就可以拿着这个去做重新开案，或者就是说打比方说大庭结束了，突然你国家打仗了，或者是说发生了什么天翻地覆的变化了，比方说突然你的家族在你的国家在你的母国受到了迫害，那这个新的状况呢在你打大庭的时候是没有的，或者打大庭之前是不 available 的，那打大庭完了之后才出现的症状，那这个时候就是说你也可以去做一个 motion to reopen， 就是 based on new evidence， 就是新的证据。 OK， 所以就是如果你们大庭失败了的话呢，你就要跟律师去做一个详细的这个咨询。So one more question, Judge. Yeah.So if someone files BIA, so earlier you said, usually somebody has 30 days to preserve the appeal. Let's say if this person files appeal, and then can the person file a motion to reopen, or does the lower court lose its jurisdiction?
Yeah, in that situation, the lower court does lose the authority to make any ruling on that case since the party had exercised its right to appeal and jurisdiction would vest with the BIA, with the Board of Immigration Appeals. But you can also make a motion to remand to the board if you feel that there was some error in fact or some error in law, and that the board would benefit from a full decision of the court as to those factors that you're raising. And then the board would make a determination whether it should be remanded back for a fuller record, or they could decide the determination on the current record before it.
那就说很多人就在问嘛，那如果说上诉到 BIA 了的时候，是不是不能提交就是 motion to reopen， 就是向低级法院去提交重新开案？那洪法官说确实是因为你在 BIA 上诉期间的话呢，那么低级法院他就没有这个管辖权了，因为你的案子现在在上诉期间。但是呢他说你也可以去提交一个就是 motion to remand to the board， 也就是说那你要求就是有一些问题的话呢是要到 BIA 那边去做一个决定，那这样子的话呢你也可以同时就是说提交另外一个 motion， 就是向 BIA 提交一个 motion。 所以呢就说具体你的案子呢要跟律师做一个详细的咨询。 那王经理，你这边的话就是针对这 BIA 上诉，就是我不知道就是在纽约这边大家很多人是会选择上诉呢，还是会放弃上诉？因为今天洪法官跟 Craig 我们都在讨论这个问题，就是我们想要一个就是大概的数据，就很多人比如说他打听失败了，他是想上诉还是不想上诉？
这个几乎是100%。
OK，
对，他们都会选择上诉的，而且选择咱们这边，他们都是就是冲着咱们的这个上庭的经验和 BIA 咱们赢的一些案例，然后他们了解到这种情况说过来的。当然，我也是在和他们详细去谈他的案件找了之前的律师，然后没有充分的展示证据，或者说在庭上这个法官比如说有点偏颇，那么这些都可以作为理由。当然，具体要看到你的庭审包裹之后才能够去律师来判定当他们是认为还有希望的，那么他们都是愿意提出上诉的。
对，就是那很多人他都很担心，就是说自己的 BIA 上诉的成功率是多少。因为确实总体上来讲，就是你大庭没过，你到了 BIA 上诉这一步的话呢，通过率是相对而言是非常低的。那之后你再到联邦法庭的话呢，那通过率就更低了。So one last thing, Judge Ham, a lot of our clients, when they decided to file BIA appeal, the first question come out of their mouth is like, what's my success rate? Like, do you have a rough data as to when people appeal to BIA, what's the success rate?
Well, that success rate depends upon what the issue that's being appealed. If it's a credibility issue, there's a high rate of denial. But if it's a credibility issue with other facets of the case that, error in law, error in fact, wrong application of the law, incorrect analysis, incorrect application of the facts to the law. If there's any of those factors, then, there is a basis that the appeal will be granted, and in most instances will be remanded back to the court for a development of a fuller record, or the board may feel that a record is not necessary and they can issue a determination on the merits of the case before it. I also want to add, even if the board does deny your case, you still have the ability to take the matter on review to the U.S. Circuit Court in your jurisdiction. That is an additional layer, appellate layer to the court, and it gets you extended opportunity to challenge the lower court decision as well as the board's decision by showing that there was an error either in the facts or the law of the case. But it can be reviewed by the U.S. Circuit Court. But in speaking directly to the success rate, as I indicated, if it's based solely on credibility, there's a high denial rate. If it's based upon other factors, there's a good chance that it will be remanded back.
OK， 那洪法官刚才讲的意思呢，就是说就是它分两种，就是刚才我们讲的，到了 BIA 这一步，就它的通过率是什么哈？那他说主要取决于你上诉是基于什么原因上诉。那上诉如果说你在低级法庭大庭的时候，法官把你拒了，说你那个可信度很低，就表示叫 credibility。很多人大庭失败都是因为 credibility， 因为法官会给你写一个几页纸的或者10几页纸的一个结论书，就说你在打庭的时候你前后不一致，你的证据不可信，这不可信那不可信，那一个单词叫 credibility。如果说是因为 credibility 的原因你大庭失败了，这种情况 BIA 上诉赢的可能性是非常小的，非常非常小。那另外一种的话呢，就是赢的可能性是非常大，也就是你在上诉的时候你翻身的几率是很大的，那就是叫 error in law 或者是 error in application of the law。 那他那个洪法官的意思就是说，如果在打大庭的时候，检察官也好或者是法官，他拒你的理由是因为他们就是采纳了不准确的法案或者是法律，或者是当时的这个法律是有问题的，那法官自己在做决定的时候，他们在流程上或者法律上犯了错误，那这种的话呢， 被推翻的可能性就非常大了。像前面王经理说的，我们2个 BIA 上诉的这个案子的话呢，都是因为我们的律师团队，就是我们在打大庭的这个，因为我们看了他所有打大庭的那个记录，然后从这中间找到了就是法官犯的这个错误，那就是发现法官采纳了不正确的法案以及就是不正确的证据。那如这样子的话呢，我们就能成功的辩护，把这个 BIA 的 case 驳回到低级法庭。但如果仅仅就是说是因为可信度的话呢，那么这个要推翻的可能性是非常的小。就例如你说我在打大庭的时候，法官不相信你说的话，你说你去教堂3次，那法官说那你总共才去了3次，你说那4次一会儿5次，那这种的话呢，我们推翻的可能性几乎是不可能的。所以就说，如果说你的现在大庭失败了，在考虑要不要上诉，或者你在上诉期间，不管你因为上诉它的这个时间度比较长，比方说有可能2年、3年、5年都有的，所以如果你对你自己的案子不是特别有信心或者不确定的话呢，请联系秦苏珊律师楼的团队，我们在纽约、在洛杉矶都有我们的律所。